16th. There, I had to unmute myself on Telegram. February 16th, 2026. Already cruising on through February now. So this is the ultimate test, although I did get some things fixed last night even after the broadcast, and I did another broadcast late last night. For those that are not aware, I got a new computer Saturday and completely redid my whole space here at home where I do my broadcasting and most of my work. Excuse me. New desk for my sister and brother-in-law. So a whole new, I completely rewired everything. Everything is like redone. Had issues with our broadcast with the toll and roll last night. So I spent about an hour doing research and into Streamlabs, and finally found some one of their help thing there, and found out, oh geez, my firewall on the new machine. Now I don't understand why I was kind of having the issues I was having before with the other machine, because really hadn't had those kind of issues for a long time up until just a few weeks ago. But yeah, I had to go in, deep dive into Windows and open it up to pass through the firewall. So, and something just came up for Telegram, which is weird. So probably would have had an issue on Telegram, but it popped up and said, "Hey, do you want to let this pass through your firewall?" And I'm like, yeah. But I had to physically add it, Streamlabs, to the to even give it permissions and log in as administrator and all that good stuff. So anybody else running into those kind of problems out there, just to let you know, yeah, if you haven't dropped frames and seem like somebody's messing with your feed, well, that's it. Oh, dang it. You know what? I forgot to check to see if X is broadcasting or not. I'm sure. Wendy, are you checking that out there for me? Anybody else on checking X? Anyway, yeah, I broadcasted live last night after that for about half hour or whatever it was, and not one issue. So far, so good tonight. Not one issue over there, and looking good so far. So, Wendy, good to see you. Freedom Fighter, Regina, Paint Gun Spooty, Kathy Watson, good to see you, dear. Palindrome. Those videos are out there on Toll and Roll. The video that we did last night, they're there. Yeah, no shape shifting tonight. Out on Rumble, we have Karen, good to see you. Jacqueline, good to see you, dear. Jameskin. Where's Mark? Mark. Wendy. Who else we got here? Ross Marley. And over on YouTube, we got Top Cat, Kneepack, and Extraordinary. So, good on Facebook. Everything's good. Still need to... Oh, X is not up. Dang it. Right, James Kim? We'll see when we start talking about the bad guys. So, for tonight, Yeah, Health Wilson out there on YouTube. I seriously thought they were messing with my feed too. It has happened before, but yeah. Always like err on the side of caution, right? Like to jump to those conclusions, but no. Semper Fi, Brother Mark, out there on YouTube. Freedom Fighter, yeah, I had somebody else go back and watch him, and it's okay. I guess it's a little bit glitchy, but not too bad. It would just drop in certain frames, but we'll be doing more. Trust me. So, without further ado, let's just jump into this here. I have a video I want to start with sharing here, and then we'll go into discuss on that kind of stuff. Which, yeah, it's gonna be good stuff, folks. Hold on.
On March 20th, 2025, defendant Byron Laws appeared in the courtroom of Judge David Fleischer in the Harris County Criminal Court in Houston, Texas. Mr. Laws had been charged with driving while intoxicated with a BAC greater than .15 on October 5th, 2021, and the case was still pending. On March 20th, Mr. Laws was represented by recently appointed defense counsel Anna Eady, who, upon reviewing Mr. Laws' file, asked Judge Fleischer to revisit the issue of probable cause. The Supreme Court determined in the 1975 case of Gerstein versus Pugh that the Fourth Amendment entitles a criminal defendant who was arrested without a warrant and charged by a formal written criminal charge filed by a prosecutor without the involvement of a grand jury to a timely preliminary hearing on whether or not probable cause existed for the warrantless arrest. The court concluded that a prosecutor's determination that
a timely probable cause determination. Now, here in Idaho, they just go ahead and do it. And they say, oh, well, you don't even have to be present for that. No, BS. So this is the trickery, you see. And this is what I'm going to be beating them up, right? But the prosecutor's assessment of probable cause standing alone does not meet the requirements of the Fourth Amendment and is insufficient to justify restraint of liberty pending trial. Yeah. Well, what about the Fifth Amendment right to due process of law? Oh, the Constitution does not require, however, judicial oversight of the decision to prosecute by information, and a conviction will not be vacated on the ground that the defendant was detained pending trial without probable cause determination. All right.
there is sufficient probable cause to press charges is insufficient, and that the issue of probable cause must be decided by a neutral magistrate. Texas law incorporates this requirement in Article 14.06 of the Code of Criminal Procedure, which states that an individual arrested without a warrant must be taken before a magistrate, quote, without unnecessary delay, end quote, and at the latest within 48 hours of being arrested. Here, a probable cause determination would have been made according to these requirements when Mr. Laws was originally arrested in 2021, but Ms. Eady requested that Judge Fleischer reconsider whether there was probable cause for the arrest.
I'm approaching on Laws.
Okay.
Is the last name. He's on bond.
Okay.
He has a BVR, but can we hear PC on this one?
Sure.
All right, there's this.
You don't think there's PC?
Laws.
No.
Yes.
You don't think there's PC?
I don't, looking at the dims, but reasonable minds can disagree, Judge.
Have we done PC on this before?
I don't know. This is an older case, and I just got appointed on it last month. So.
Did you already approach on PC on this?
I have not.
Don't worry about it.
I'll just be honest, Judge. I had just.
Now, remember that this guy here he does okay. I mean, I've seen quite a few of his videos now, and typically the defendant is actually present for a probable cause hearing. Yeah, supposed to be present, because you also have the right to cross-examine. But these are things that we're going to have to deal with. But clearly, this court here, and with this David Flesher, hope I didn't mispronounce his name, but for the most part, I think he's an alright, fair kind of guy, to a certain extent. But the fact is, they most certainly are doing things different than we do here in Idaho. Now, we don't have these kind of probable cause hearings in the very beginning. They'll show on the document, that, oh yeah, the probable cause hearing was held, but I didn't get any notice of hearing, and it's supposed to happen at the very, very, very beginning. As soon as you're arrested, you're supposed to be taken before a magistrate for that initial appearance for a probable cause hearing, for an examination. And then it's supposed to be a determination whether or not there was actually a crime committed, right? And then the judge can say, okay, bail, or make a commitment to commit to jail if you don't post bail. And we're supposed to be able to post bail right there in front of the magistrate. We're not supposed to be taken to jail. You know, this is another problem of due process of law. I don't know how many other states do it like that, but I'm not sure what state this is in, if anybody knows for a fact what state this is in. But I guess somebody out here saying that this is in Texas. I don't know.
Assumed because of the age of the case that PC had been done. But
Of course it has been.
right.
But there's a new set of eyes, you know? Okay, ready?
Yes, Your Honor. Sorry, just reading through it. 2021 case. On October 5th, 2021, the officers were dispatched to a DWI call. The officer were dispatched to a possible intoxicated driver call. The witness stated he observed the defendant to go in and out of lanes while making a turn on the highway, pitch traffic. The officers conducted a traffic stop. The officer observed the defendant to have glassy eyes, slurred speech, an odor of an alcoholic beverage, and poor balance, and a quarter full of quiet, please, cold beer inside the vehicle. The FMSTs were conducted. It was a 6 out of 6 on the HEN, a 7 out of 8 on the walk and turn, and a 4 on like stand. The breath is a 0.15.
So according to the DIMS, which is the sworn statement that we use for PC, it just says the officers initiated a traffic stop on the defendant's vehicle at an address, and there's no reason given in the DIMS for the stop.
She read something different.
That was
Yes.
not in the DIMS.
That seems to be from the offense report.
Sure, I mean, what's...
But I thought for PC, we just used the DIMS because that was sworn to, and not getting into the.
Show me where it says that. I don't know of any rule that says that it's PC has to be done on just the DIM.
Okay.
You know, I don't. If you can direct me to something,
Okay,
but I've
and
never.
that just may be my misunderstanding of a
Yeah,
policy.
I don't. And I've heard this before.
Okay.
Right, but I can't. I've never seen anything.
A misunderstanding of the policy. See, they're all operating under policy. There's all pretended acts of legislation. It's policy.
Where someone has ever directed me to saying, "Hey, PC is only
Well, it's
has to be just on the DIMS." You
because
know.
the DIMS is sworn, and just like when Judge Powell was up here and he wanted to get into the facts, he couldn't.
I mean, if he's getting into the facts, then that's something different, right?
Well, and getting into
That's a sworn document too.
the offense report's on a sworn document.
I mean, I guess, Your Honor, my
Yeah, the officer's report is not a sworn document.
They're using DIMS, taking the offense report. And also, I have never seen a rule where we have to rely solely on the DIMS for probable cause, since it's probable cause. In fact, when we go to the grand jury, that's all offense report, that's all DIMS, it's everything that comes in, it's even evidence, and that's probable cause.
Yeah, I don't know. I don't think that, I mean, let's look, because I don't know, you know?
Okay, I'll find
And
out.
I'll,
Go check with
sure.
Ms. Rogers.
Ms. Eady asserts that a probable cause determination must be based on the allegations in the DIMS and not the factual allegations in the offense report. DIMS stands for the District Attorney Intake Management System, which police officers use to electronically submit criminal charges to the Harris County District Attorney's Office. When someone is arrested without a warrant, the arresting officer contacts an assistant district attorney to determine whether there is probable cause for the charge. Once the prosecutor authorizes the filing, the officer logs into the DIMS and completes a series of electronic data screens, including officer information, defendant descriptors, defendant identification method, charge information, summary of facts, witness and complainant data, and complainant property info. According to the DIMS manual, the summary of facts must include a concise, factual narrative explaining who, what, when, where, and how the alleged offense occurred. This summary is used.
Now, something to pay attention to right here. This is the considered the 4 W's of who did what, where, and when. And then he's saying, oh, you got to add the how and the why. Well, not necessarily how and why. Right? That's kind of a misnomer. But if you do know the how and the why, well, then I guess you can explain that. But mainly, it's the 4 W's. Who did what, where, and when. I can't, in certain situations, how are you going to explain why they did something? Because they're corrupt? And the how they did it is the what they did. So, but this is key. The 4 main W's, who did what, where, and when, in it, like in an affidavit. That is what's required. Short, clear, concise statements of who did what, where, and when. So keep that in mind. Learn that.
By the district attorney's office to show probable cause for the warrantless arrest, and the manual specifically notes that reference to an arrest report is not acceptable. The officer must specifically state all of the essential facts. Additionally, once the DIMS is sent to the DA, information in the record cannot be changed, added, or deleted. Now, by contrast, an offense report is the formal police narrative written by the investigating officer after the arrest. It provides a detailed account of the incident, including witness statements, observations, test results, and other evidence. Unlike the DIMS, the offense report is often supplemented as the post-arrest investigation unfolds and additional details are uncovered. Here, Ms. Eady is arguing that only the DIMS can be used for, and that the DIMS in Mr. Law's case did not contain enough information to establish probable cause for his initial arrest.
So you're saying that the DIMS has no reason for the stop, right? Is that what
Yes.
you're saying?
The sworn statement, and speaking with Ms. Rogers, we're looking, but it's not,
And I'm looking too.
okay.
I am too.
There was a class action lawsuit, and as part of the settlement, the agreement was that Harris County would use the DIMS to support
Okay,
PC, but we're getting that all together.
me too.
Okay.
For the 26th.
Was there a result for that?
Yes.
Or is it in action now?
No,
No, this was some time ago. So this was before the DIMS summaries had an oath or affirmation at the bottom of it. So there was a class action lawsuit brought by the Civil Rights Board. And out of that lawsuit, it was just allegations of Fourth Amendment violations, because when a warrantless arrest occurs, the Fourth Amendment requires that a neutral magistrate make a finding of probable cause supported by oath or affirmation. So as a result of that lawsuit, Harris County settled and said, okay, we're not going to concede that we were violating the Fourth Amendment, but we will now include an oath or affirmation.
Okay.
So I think it is a Fourth Amendment issue.
I'm curious, so I'm curious, for PC purposes, can state use an offense report to supplement a DIMS? Or are we strictly going in the four corners of the DIMS and nothing else? I don't know.
Well, the four corners of the DIMS is what's sworn to. The offense report is not.
I find that really weird. How is it that they're creating an offense report and they don't swear to it? You know, because there's, in the offense report, you also have a search warrant. Like 9 times out of 10, you've got a blood search warrant, and that's sworn to.
That, Your Honor, if the officer makes something up into the offense report, he is committing a crime. So I mean, I don't say that the offense report is not sworn to. It's a government record that this officer is putting his name on. If he makes something up or if he lies about something, that is a crime.
Right, but filing a false government document is a different crime than perjury.
I get it, but
Wouldn't that be filing a false?
Right, but perjury is.
Wouldn't that be
official
filing a
document?
false
different
document?
crime.
No, but it would also under the purview of filing a false, you know.
Well, Judge, if
A false
if an officer
document.
came
Yeah,
into court
yeah,
and was asking
yeah,
for
that's
you
some
to
stuff that I
sign a
just
search
recently
warrant,
discovered.
and they just gave you their offense report, that would not be enough for their search warrant. And it's kind of the same idea. Because this is a warrantless arrest, there has to be someone swearing to the facts to support probable cause for that arrest. And similarly, with the search warrant, it has to be supported by oath or affirmation. This wasn't a warranted arrest, it was a warrantless arrest. And so it must be supported by probable cause. That includes an affidavit.
See, now this is what I busted them on a couple years ago in a case. I was like, well, no affidavit there. Well, this case that I'm getting ready to go to trial on, they're like, oh crap, we got to make sure there's an affidavit. And so he did that affidavit, but the thing is he knows that I questioned him in the video about the crime. What's the crime? But he put in there that there was no crime. So if there's no crime, at the time of the stop, he didn't witness any crime. Huh. Yeah.
Was there blood in this case? Right. Okay, give me 5 minutes.
Okay.
Huh? Okay.
If it's okay with you, we'll take
Can
a
you
look.
show them?
yeah, that's fine.
Ms. Eady and her colleague mention a class action lawsuit involving probable cause determinations in Harris County. The case they're referring to is Lomas versus Harris County, which was filed December 28, 2016 by attorneys from the Civil Rights Corps and the Texas Fair Defense Project. The lawsuit complaint alleged that Harris County practices violated the Fourth Amendment by continuing to detain arrestees without a probable cause determination by a neutral magistrate based on facts supported by an oath or affirmation, as the DIMS report used to find probable cause at that time was not a sworn statement. On November 1st, 2017, the case was resolved through a settlement agreement. Harris County did not admit to any violations of the Fourth Amendment, but the district attorney did agree to change the process of presenting probable cause statements for warrantless arrests by requiring the officer to swear to the facts as they are being inputted into the DIMS. According to the settlement agreement, the system was modified so that every time an arresting officer input facts relating to an arrest in DIMS, they would have to click a box to declare under penalty of perjury that the facts they have reported are true and correct based on information and belief. In other words, the DA agreed to use sworn statements from the DIMS report in order to establish probable cause.
Anna, you ready?
Yes, Judge.
Mr. Laws, come up. We have court orders for a reason, and when you don't follow court orders, bad things happen. Do you understand?
Yes.
You were ordered to get an interlock and you didn't get it, or a portable device, and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right, good luck.
Thank you, Judge.
Now, Okay.
We were going through the lawsuit and, you know, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean,
Huh. Holding it to a
theoretically,
higher
could I
standard.
weasel out of it? Yes, but I don't want to, you know? I want to stick with the agreement that the county came to with the district attorney's office, you know?
Not saying do this, I'm just for curiosity.
Yeah.
It's all through.
The dim-
The thing is he just, you know, lambaded that man there for not getting the interlock stuff, but yet there was never any probable cause to begin with. So they violated his rights right from the get-go. And he did the right thing by dismissing the case right there. But like, hey, you know, that's a court order, blah, blah, blah. Well, how about the law? That's an order by the people. So, you know, here's the thing. They did that lawsuit, and that's what they're talking about now. It's like, oh, well, holding us to a higher standard. When are we going to get back to the law? When are we going to get back to the law? So, this is what I'm working on, right, folks? Is what the law is. Now, back to this, the history of the criminal law of England by this guy Stephan that in State versus Clark case referenced. Stop it. Quite interesting here. What and I just came across this yesterday. The Aziz of Arms and the Statute of Winchester fell into disuse, but the right of summary arrest in cases of felony continues to this day to be the law of the land. And though the sheriff's personal intervention in the matter has practically fallen in disuse, the justices and constable are still the authorities by whom the system is worked. One great alteration was made in the system just described between the 14th and 17th centuries. During that period, summonses and warrants superseded the old hue and cry, which practically fell in disuse. The history of this substitution is curious. Justice of the peace were first instituted in 1326. Their duties were described in the most general terms. They were by one Edward, blah, 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 assigned to keep the peace. By 34 Edward, and in 1360, they were empowered to take and arrest all those they may find by indictment or suspicion and put them in prison. But neither in these nor any other early statute with which I am acquainted is there any provision which enables them directly to take an information as to the commission of a crime and issue a summons or warrant for the apprehension of the suspected person. Uh-oh. Sarah out there on Facebook, Idaho doesn't do law, and another 20. Wait a minute, or was it? Just seeing your comment there about no oversight, Idaho courts, Idaho judicial. Yeah, it's because we're supposed to go to the legislature. That's the shit made up. That's the judicial council. Is the shit made up? That's the fox guard in the hen house. It's trickery. It's even in the Idaho code that talks about that. That you could file a complaint against a judge with the judicial council, but that is an alternative process, right? That and that there is a different process that we could use. Gee, I wonder what process that is. That's called the impeachment process, and that is done in the legislature. The legislature is where we go for the redress of grievances. Okay? Petition the legislature for the redress of grievances. That's where we're supposed to be going. In the proper form of a petition. It has to be written. All right, here we go. I'll just do this real quick, because so many people just don't get it. So I'm on my website, kirkslawcorner.com, that petition there. Here's the proper form of a petition, folks. This is what they look like. 118th Congress of the United States of America. Now, this one is in Congress, so if you're addressing the state legislature, then you're going to be in the legislative session of the Idaho legislature, right? A humble petition of me. Okay? Statement of facts. 1, 2, 3. Prayer for relief. Petitioner, signature, done. 2 pages. That's it. That is the proper form of a petition. And notice that it's notarized. Again, this is the proper form of a petition. Please take notice. Learn. This is the proper form of a petition. And by the way, this font up here is called diploma font. That's proper formatting. Now, per se, you're right. It doesn't actually have to be perfect like this. It can be handwritten. But it must be substantially in this form. In fact, when I was out in D.C. back in 2018 with John Gentry, there was actually a petition to Congress for divorce because her husband had taken off and she couldn't get him served with the divorce paperwork. Couldn't find him. So she wrote in there all those statements of facts. I've been trying to get him divorced, and it was like that was right when Chris and John and I were working together there, and was in there and was like, holy crap! I'm like, John, you got to come over and see this. Right on the wall at the National Archives was that petition for divorce. For Congress to grant her a divorce. And, basically it was, the statement of facts was, I've been trying to find him, I want a divorce, blah, 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 I can't find him, he's been gone for a certain amount of time, prayer for relief, please grant me a divorce from this jerkwad. That's basically what a petition is. But you have to have the prayer for relief. What are you demanding them to do? Now, if you'll take notice here, when you're dealing with like public servants and that kind of stuff, what am I putting here? Wherefore the petitioner and the undersigned demand the following relief and hereby instruct our public service to discharge their duties as instructed by the people. To create a committee and open an investigation to verify claims 1 through 3. To declare war pursuant to Article 1, Section 8, Clause 11, for a foreign invasion. I mean, I'm citing the law. To call forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions, pursuant to Article 1, Section 8, Clause 15. There's no United States Code here. There's no need for any of that. It's right in the supreme law of the land. Just like our rights are enumerated in the Declaration of Rights section of our so-called state constitution. So, there you have it, folks. I'm showing you what a proper petition to the legislative branch looks like. Right on my website, KIRKSLawCorner.com. Click on petition. There it is. We've been putting this stuff out for years. But anyway, so back to Stephen here and his history of the criminal law. Right here, he's saying that no. No prosecution by information. The statute above quoted give them no authority for the apprehension of offenders than was by the common law inherent in every constable and indeed every private person. Now see, this is just a little bit before what they cited in this State versus Clark case, as I was going back to get what it says in here to put in my paperwork that I'm getting ready to file in jury instructions in the State versus Clark case. Yeah, I'm going to be instructing my jury on the law. But yeah, I wonder if there is any other. Is it going to let me do it? Oh, it's hiding behind my. Like, where is it? Let's see if we can find information. So there's one place. Yep. Huh. So what is it saying here? That the statutes were as follows: by 1 and 2, Philip and Mary, in the 1554 it was enacted that when any person arrested for manslaughter or felony or suspicion of manslaughter or felony be bailable by the law, is brought before any two justices, they are to take the examination of the said prisoner and information of them that bring him of the fact and circumstances thereof, and the same or as much thereof as shall be material to prove the felony shall be put in writing before they make the bailment. The examination and bailment are to be certified to the court, and all such as do declare anything material to prove the said murder. Murder is not mentioned in the earlier part of the act. Manslaughter, offenses, or felonies, or to be accessory or accessories to the same as aforesaid, of the court of jail delivery. This act was confined to the case of prisoners admitted to bail. It was followed in the next year, 1555, by an Act 2 and 3, which recites that it does not extend to such prisoners as shall be brought before any justice of peace for manslaughter or felony, and by justice shall be committed to ward for the suspicion of such manslaughter or felony and not bailed, in which case the examination of such prisoner and others that bring him in is necessary, rather more than where the prisoner shall be led to bail. The act then goes on to reenact with the respect to cases in which prisoners are committed the provisions of the act of the preceding year as to prisoners' bails. These statutes continue to be enforced in the year 1826, when they were repealed, reenacted, and extended to misdemeanor. Really, in 1826. So, I mean, this 1826, we're already into it. So, page are we on here? Oh, we're way past. We have to go back up. $221, nope. 219. Yeah, okay. So, I mean, this is just another source, but the reason why I'm in this is because Idaho Supreme Court cited it as an authoritative source. So, hey, there you go, Mark. Good to see you, brother. I didn't catch when you actually came on. And G. Hendrick, good to see you. A newbie out here. Diesel D's. Must the affidavit for probable cause be completed at time of arrest? Very good question. Very, very, very good question. Very pertinent here. So, according to the Criminal Practice Act of 1864, the accuser is actually supposed to take the stand, be sworn in under oath, testify. That is supposed to be reduced to writing, signed, sworn, and subscribed right there on the spot. And then the defendant is allowed to cross-examine, unless the defendant is not there and this is just somebody who's laid a complaint before the court. So, but that's, getting a warrant for an arrest, not actually making an arrest without a warrant. But if you're going to make an arrest without a warrant, you're still supposed to arrest them, take them before a magistrate. The accuser, the complainant, the actual complainant, right, is the one that's supposed to take the stand, because there's supposed to be an injured party, the corpus delicti, all of the elements of a crime. So, the affidavit, right, is actually created based on the testimony after you are sworn in. You're supposed to lay the complaint before the magistrate, take the stand, testify, reduce it to writing, sworn and signed and subscribed by the magistrate, right? Signed by the complainant, the injured party, and then subscribed by the one who issued the oath, the magistrate, because the magistrate issues the oath, and that is the requirement of the Fourth Amendment. And then, when it comes to the Fourth Amendment and issuing warrants, there's another part to that Fourth Amendment that they most certainly want to subvert and forget. The right of the people to be secure in their persons, houses, papers, and effects, which is property, okay, against unreasonable searches and seizures, shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation. And that's exactly what they were just talking about in that case, and that's the reason why I wanted to show that video there, is because it wasn't supported by oath or affirmation. The DIMS is what they call it. But the fact is what's the actual process to obtain a warrant? The problem is they made an arrest for something that's not an arrestable offense without a warrant, and that is particularly what she was arguing about probable cause to make the arrest. See, this is what they're all trained to do, right? These policy officers is they're trained to, find anything to make a traffic stop. Yep, we're going to make a traffic stop here. Oh, okay. Your taillight's out. You didn't use your turn signal. You went across the white line. You didn't stay in your lane. You ran the stop sign. It's like, really? Those are arrestable offenses without a warrant? Huh. I find that quite odd that we're allowing this to happen. So, then, what they're trying to do is to, oh, well, I smell something. I smell alcohol, or I smell marijuana, or I smell something, and try to get you out of the car and under arrest for something. And then they call it search incident to arrest. Oh my gosh, Jacqueline. I just saw your comment. You started a KIRK app with Grok? Awesome. We need to talk. So, this is what they're trained to do. Is they have to go look for the crimes, right? These are all traffic infractions. They're not actually arrestable offenses. And then they jump into that, see what we can find. And like in that particular case, oh, it was a DUI. He was driving drunk or while intoxicated. Okay. But what was the cause for depriving the man of his personal liberty to begin with? What was the crime? And see, this is where they have to get into their reasonable and articulable suspicion of a crime that is an arrestable offense without a warrant. And so that's the reason why I was reading that State versus Clark case. Is because it popped up when I did a search for cases in Idaho about what an arrest could be made for. And see, this is what blows my mind. They know. They know what the common law is. They went and did the research. This was in 2019. They had to amend Title 19, subsection 603 on making an arrest because of that case. And a previous case in the Green case, which they cite in the State versus Clark case. So, it's like, how are they? They're willfully doing this, folks. Now, the other part about this warrant, what is it? What is the next part about issuing this warrant? Is the warrant has to state with particularity the place to be searched and the persons or things to be seized. So, like in Idaho, which I'm pretty sure everywhere, anywhere in the state of Idaho. No. No. That does not state with particularity the place to be searched. It's actually supposed to be an actual place, your house, your domicile. So, and then the persons or things to be seized. So, why aren't they following those? They're getting away with this stuff because of our lack of knowledge, folks. I'm telling you right now. In the State versus Clark case, this guy, was busted after the fact of touching this woman out on the beach, and then after she got home, she called it in. Then they went to the beach and found him and arrested him. Okay, and then search incident to arrest, they found methamphetamine, marijuana, and paraphernalia on him. Felony and a couple misdemeanors. They actually got him on the felony, right? Yep, because that's what they want. They want the big stuff. And then, of course, they dropped the other charges because they got him on the felony. But he appealed it, went all the way out to the Supreme Court, claiming that, hey, you made an arrest for an alleged misdemeanor that was already completed. And the court said, yeah, you can't make an arrest. Well, they go even further in the State versus Clark case. right? Let me just pull that one up, just for the shits and giggles, because we're right here. State versus Clark. Where are you? What? I thought I put you in there. Oh, no, it's in the Idaho specific case law. So here's the State versus Clark case. And this is again what led me down the rabbit hole. Page 6 right here. Provisions of the Idaho Constitution must be construed in light of the law prior to their adoption. Now, in light of the law, prior to the adoption of the Constitution, because the constitutional guarantee against unreasonable seizure of the person includes an arrest. The Idaho Constitution incorporated the principles regarding arrest in Idaho statutory and common law in 1890 when the Constitution was adopted. What's statutory law? How come they don't cite the statute? What was the statute prior to 1890? Recently in Green, this was, I think it was 2015, interpreted Idaho Code Section 19.6036 and 7 and explained their relation to Article 1, Section 7 of the Idaho Constitution because these subsequently enacted arrest standards did not exist at the time the Idaho Constitution was adopted, and because they were not incorporated by constitutional amendment, they cannot be considered part of the constitutional standard for what constitutes a reasonable seizure of the person, a reasonable seizure. What is the reasonable seizure? You gotta have evidence of a crime. Green held because the constitutional guarantee against unreasonable seizure of the person includes an arrest. Well, yeah, of course, it's an arrest. The Idaho Constitution incorporated the principles regarding arrest in Idaho statutory and common law in 1890 when the Constitution was adopted. Okay. What was the so-called statute then? Oh, was that the Criminal Practice Act of 1864? That's the only statute that I'm aware of. But I like how they say here, however, we conclude that this statement in Green is overbroad. Green should stand for the principle that pre-existing statutes and the common law may be used to help inform our interpretation of the Idaho Constitution. See, here's the problem. They keep trying to say it's the Idaho Constitution. That's why they put the Declaration of Rights into the Constitution, claiming that these are constitutional rights. No, it's the common law. It's the people laying down the law, and then we institute government to secure these rights. See, that's the way it was before the Reconstruction Acts, is that declarations of rights were done first, and then the Constitution was separate. They don't want us to know that. So, that's why do you think the Bill of Rights is separate from the Constitution? The federal Constitution. Huh. I don't get it. Imagine that. So when considering the Idaho Constitution, the primary object is to determine the intent of the framers. Well, did we forget that we already had a republican form of government and we already had the common law from 1776? So, like they say here, unfortunately, Article 1, Section 17 was adopted without debate. In the absence of the words of the framers, rights guaranteed by the state constitution are examined in light of the practices at common law. There's that at law. And the statutes of Idaho when our constitution was adopted and approved by the citizens of Idaho. No. We don't need the statutes. The common law is the common law. But see, they're still trying to grab that power. Well, what were the statutes at the time? The court has long taken this approach in interpreting our state constitution. We must determine the meaning of the language is used in Articles. See, I don't get this. Language used in Article 6, Section 3 of the Idaho Constitution. In the light of conditions as they existed at the time the Constitutional Convention was in session in July of 1889. Now, I've looked at this Article 6, Section 3, and I'm like, this makes absolutely no sense. What the hell they're actually referencing here? Suffrage and elections? Section 3, disqualification of certain persons. No person is permitted to vote, serve as a juror, or hold any civil office who has at any place been convicted of a felony and who has not been restored to the rights of citizenship, or who, at the time of such election, is confined in prison on conviction of a criminal offense. What does that have to do with Article 6, Section 3? I don't know. So we have explained the significance of case law and statutes existing in 1889 as follows. Because many of the delegates to the Constitutional Convention were outstanding lawyers, all esquires, in their day, were generally presumed that they knew and acted on such prior and contemporaneous interpretations of constitutional words which they used. Thus, a review of the common law is in order. Well, wait. Where's the statutes? You said case law and statutes. Now you want to switch over to just the common law. Now, again, and trying to educate the people on just exactly what they can make an arrest for. And here again, they're citing Blackstone's commentaries on the laws of England. Why are the first thing they're going to for a source of the common law is Blackstone's commentaries on the laws of England? I'm finding this more and more. Okay? And then the next one is that Stephan one that I'm just reading from right there. That's this one. And see, when this is cut off here, but see, well, I'll just go ahead and read it too. The constable hath great and original inherent authority with regards to arrest. He may, without warrant, arrest anyone for a breach of the peace. And what? And carry him before a justice of the peace. Where does it say take him to jail? That's the common law. This is a review of the common law as they state they cite in this Ha, Grok said Blackstone was for England. Well, Grok needs to read Blackstone because at the time of the writing in Blackstone, he actually references in America so get it together, Grok. And in case of felony actually committed, or a dangerous wounding whereby felony is like to ensue, he may, upon probable suspicion, arrest the felon. Okay? And then it says, there were, now by this scholar, Stephan, which we're going to, back to that, what I was just reading, there were indeed still a large good many differences of considerable importance to the procedure relating to the prosecution of felonies and misdemeanors respectively. The most important are that as a rule, so this is their rule of law, a fundamental principle, right, in 1883. So we're right in the middle of America. This is after 1776 and after the Reconstruction Acts. And this is a scholar of the common law. And by the way, the common law is worldwide. It's the law that is common to all. So stuff that in your pie hole, Grok. Now let's continue reading here. What does it say? As a rule, a person, what? Cannot be arrested for a misdemeanor without a warrant. I mean, how else can you lay this down? In 1883, as a rule of law, we cannot be arrested for a misdemeanor without a warrant. And Mark, in the New York State Rifle Pistol Association versus Bruin case, in what was that, June of 2020, was it 2022 or 2023? 2023. Anyways, this is what they went to. Blackstone's Commentaries on the Laws of England regarding the Second Amendment. Bingo, Wendy. Yep, Blackstone compares the English common law to the American common law and makes the distinction between the two. And that's basically what I was saying there for Jacqueline to send that over to Grok and say, hey, the Magna Carta of 1215 is to all English-speaking nations as the common law. So, okay, Mark, you're confused. The courts let us use Blackstone's, but not the Constitution? No. We have to. We have to. We have to be the law sayer, the lawyer, bring the law. Right? And that's why I'm trying to teach people the law. Right, Karen, see, but you're not quite comprehending about the common law, right? The common law is the law, rights as the law that are common to all. And this was even told to the kings. Okay? Remember, even a king or a queen or a prince, they're all servants of the people. They never let you quote the Constitution? Huh. Well, I've actually had that one time try to tell me that, and I said, well, is the Constitution of the United States of America in full force and effect right here, right now in this courtroom? Yes or no? Yep. The Constitution of the United States of America is in force in this courtroom right now. Good. So we go by the common law. But this right here is very damning for them. As a rule, a person cannot be arrested for a misdemeanor without a warrant. Plain and simple. The only thing is for a breach of the peace. But in 1883, this scholar of the common law wrote the most important are that, as a rule, a person cannot be arrested for a misdemeanor without a warrant. So, let me did I have that? What? Where is... Oh, there it is. So here's my jury instruction. When peace officer or private person may arrest. A peace officer may make an arrest in obedience to a warrant delivered to him at night when the warrant is for a felony. So that excludes misdemeanors. A peace officer or private person may, without a warrant, arrest a person. Whoops. I better get that one out of there. When a person arrested has committed a felony, although not in his presence. When a felony has in fact been committed and he has reasonable cause for believing the person arrested to have committed it. At night, when there is reasonable cause to believe that he has committed a felony, he may take before a magistrate any person who, being engaged in the breach of peace, is arrested by a bystander and delivered to him. Guess what I cited? Criminal Practice Act of 1864. Yep. And then I cited exactly what's in State versus Clark there. Exactly what they put in there. The constable of the great authority, original inherent authority with regard to arrest, he may, without warrant, arrest anyone for a breach of the peace and carry him before a justice of the peace, and in case of felony actually committed, or a dangerous wounding whereby felony is likely to ensue, he may, upon probable suspicion, arrest the felon. And then what did I put in here? No. As a rule, cannot be arrested for a misdemeanor without a warrant. So they're screwed. And then what did I do? I went to the actual diction, what was in there. The actual diction from Stephen, History of the Criminal Law of England, page 193. The result of his inquiry may be thus stated. 1. Any person may arrest any person who is actually committing or has actually committed any felony. See, I've been telling you guys, we all have the right to make an arrest. Number 2, any person may arrest any person whom he suspects on reasonable grounds to have committed any felony if a felony has actually been committed. Number 3, a constable may arrest any person whom he suspects on reasonable grounds of having committed any felony, whether in fact any such felony has been committed or not. And that's the constable. And then the next paragraph says, the common law does not authorize the arrest of persons guilty or suspected of misdemeanors, except in cases of actual breach of the peace, either by an affray or by violence to an individual. In such cases, the arrest had to be made not so much for the purpose of bringing the offender to justice, as in order to preserve the peace. Now that's what's in the Treatise on Arrest and False Imprisonment, is about only goes so far as stopping the breach of peace. Because that's what an arrest is stop. Right? That's it. Just stop. That's an arrest. I know, Karen, when we're talking about, in this sense, any person, right? At this point, it would be a defendant, the accused. That's the person. Except in cases of breach of the peace. That is the exception to the rule. I know, very troubling for me too. But, you know, we have persons, right? We have mother and father as persons. Defendant is considered a person, you know, in your person. But ultimately, and I've talked about this before, we're man, creations of God, period. And then the next part of this is, and the right to arrest was accordingly limited to cases in which the person to be arrested was taken, in fact, or immediately after its commission. Where? Immediately. Carried before a justice of the peace. But in the three here, yeah, it's not given any authority according to Stephen what he actually wrote there. So the judge is going to have to read this to the jury. We have the right to have a fully informed jury, but we have to do this. Just so you're aware. And that's why I was like, why didn't they continue reading right here? The common law as it developed throughout the United States prior to it appears to have been unanimous in agreement with articulated above. Or wait, no. Why didn't they read that next part there? The next paragraph? See, they didn't actually properly cite what it said there, but what they did cite was the fact that it said those three things. Because that's exactly, word for word, right there. 1, 2, and 3. Exactly what I put in the judicial notice, or jury instructions. And then here is the next, paragraph. The common law did not authorize the arrest of persons guilty or suspected of misdemeanors, except in cases of an actual breach of the peace, either by an affray or by violence to an individual. Not person, but individual. So, that's it. I mean, how do you deny this in 1883? When this was written, how do you deny this? That's the exception to the rule. Except in cases of an actual breach of the peace, either by an affray or by violence to an individual. By violence to an individual. You mean there's a victim? Right, Jacqueline? That's it. We just need to cite the common law. This is the common law. That's the thing. See, the common law per se is lex non scripta, the unwritten law. And where we're actually looking for the common law, again, well, I've got that one, which would be gee, I wonder what American jurisprudence has to say here about them damn constitutional provisions. American jurisprudence, second edition, Constitutional Law, Section 100, August of 2017 update. So this isn't old stuff. This is relatively new, right? Back in the day. I mean, it's 9 years ago now. Can't believe it's already been that long. But Section 100, construction of constitutions, construction to determine operative effect as self-executing or not self-executing in general, right? This is about whether or not constitutional provisions are self-executing or not self-executing. And what does it say? Even without the benefit of a declaration that they are self-executing, constitutional provisions in bills of rights and those merely declaratory of the common law are usually considered self-executing, as are provisions which specifically prohibit particular conduct. So, a clear distinction exists between the questions whether constitutional provision is mandatory or directory, and whether it is self-executing or requires legislation in order to give it effect. A provision may be mandatory without being self-executing, and a provision may be self-executing even though it contains some mandatory language. But the thing is, okay. Oh. All right. Let's go back to that. What does this say? This is a Declaration of Rights. This is the common law. Right here, folks. This is the common law. Declaration of Rights, laying down the law. Rights as the law. This is the common law. And none of this needs any legislation. This is all self-executing. There is no grant of authority to make any legislation regarding this. Go right back to State versus Clark. What did they say there? Well, we can't. What does this mean? What does Article 1, Section 17 mean? We can't look at a statute because this is a Declaration of Rights. And it says, shall not be violated. That's mandatory language. That is prohibiting conduct. Now, when we're talking about reasonable searches and seizures, okay, is it a felony? That would be a reasonable arrest. Is it a breach of peace? Breach of the peace, which are assaults and batteries? Those are threats of violence or acts of violence. Hello? Who in their right mind would not say, hey, stop? Even in a verbal threats of violence, assault, or in physical violence, a fight, touching, whatever. Yeah, anybody can go, hey, stop. That's an arrest. That would be reasonable. Now, is it reasonable to make an arrest for not having plates on your private property? I don't think so. That's not a reasonable arrest. Mark, that video that I just showed tonight, that bar member knew it. That's why she was challenging the probable cause. What was the crime that he was making the arrest for? That's not a crime. Now, let me see. Let me pull that up. Let me see. So this is their objection to my motion to suppress and motion to dismiss. Here's their statement of facts, right? Not bearing any license plates or temporary tags while driving south on Veterans, blah, 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 Officer Jantz activated his overhead lights and conducted a traffic stop on the vehicle, and the vehicle yielded. Okay. The driver refused to provide, calling me a driver, refused to provide Officer Jantz with any identification or identify himself in any other manner. After being told multiple times, and Mr. Pendergrass replying, I do not consent and I do not answer questions, Officer Jantz informed Mr. Pendergrass he was being placed under arrest for resisting and obstructing. Resisting and obstructing what? What lawful arrest were you making? And this is the trickery. What is obstructing? Gee, there's a jury instruction for that. And it's their own jury instructions. Where is it? Where is it? Okay, here's their own jury instruction on obstructing. Obstructing an officer by false report. In order for the defendant to be guilty of obstructing an officer by a false report, the state must prove each of the following. On or about in the state of Idaho, the defendant knowingly gave a false report to a person the defendant knew was a peace officer. How is that obstructing? See, they're claiming obstructing is not answering their questions, is obstructing. That's what they're trying to construe it to mean. What is obstructing an officer then if it isn't? This is your own jury instructions. This is Idaho Criminal Jury Instruction 1265, created by the judicial branch. And not a false statement in response to a question asked by an officer. Uh-oh. No, that's making a false report to an officer is obstructing. Is a statement, written or oral, made upon the initiative of the defendant to a peace officer for the specific purpose of having some action taken with respect thereto. That's what obstructing an officer is. Huh. Now, I thought I did see 1265. Here's 1260. Let's see what this one. In order for a defendant to be guilty of resisting or obstructing an officer, they had delay. I've already amended this one. They had delay in there because he didn't say anything about delay. Right? In order for the defendant to be guilty of resisting or obstructing the officer, the state must prove each of the following: on or about in the state of Idaho, the named defendant willfully resisted, obstructed such officer, a public officer, in the discharge or attempt to discharge any duty of. See, now they're misconstruing that. What is obstructing? See, that's void for vagueness, because they don't actually define what obstructing is, other than obstructing an officer by false report. Where's the definition of obstructing? This is the only one I could find related to obstructing an officer. So, yeah. But let's go back over here. Look at what they say in their response, right? I'm going to, again, use this stuff against them. And this is so stupid. The court has jurisdiction over the defendant. The defendant cites to the authority of the Constitution a number of occasions, but failed to cite the state's legal authority under the Constitution to create and enforce laws. That's because the Constitution doesn't grant them the authority to create and enforce law. It's policy, not law. The 10th Amendment of the United States Constitutions and the United States Constitutions states the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. U.S. Constitution, Amendment 10. Because the Constitution of the United States does not delegate car registration nor driver licensing, that power is reserved to the states. Okay, fine. I'll go with that. Where in the Idaho Constitution does it say that you can do car registration and driver licensing? That power has to be delegated. Where is it delegated? Then they go to this, 19-301. Every person is liable to punishment by the laws of the state for a public offense committed by him therein, except where it is by law caused exclusively in the courts of the United States. Evidence that a prosecutorial act was committed within the state of Idaho is a jurisdictional requisite, and proof of such must be shown beyond a reasonable doubt. Are we talking about a crime here, or what? Here, officer observed the defendant driving to the parkway in Garden City, and the original stop was for violation of, for not displaying a back license plate, which eventually led to resisting and obstructing charge when the defendant refused to provide his identification to the officer. Okay. Where's the crime? Is that a felony? To not provide identification upon demand? I don't think that's an arrest. That's not a reasonable arrest. All right. Good night there, freedom fighter. Yeah, I only got about another 10 minutes here. But then they go, okay, here's their best ditch effort to subvert all of this. I mean, they did a pretty good job trying to subvert. That's all. Let's go back up here. The defendant cites to the authority of the Constitution on a number of occasions, but failed to cite to the state's legal authority. Where was it? Okay. Defendant's motion to suppress and dismiss contains numerous statements of beliefs and alleged facts. However, it fails to cite any statute, rule, or governing case law that supports such a suppression or dismissal. I cited real law. I don't need any statute or rule of procedure or any governing case law. It's already the law. I don't. Why would I need a statute or rule of procedure or some case law where the judicial branch gives their opinion when I'm citing the actual law? We don't. But here we go. Let's hear what he goes to. Oh, Article 1, Section 17 of the Idaho Constitution guaranteed the right of the citizens of Idaho. No, it's the right of the people, not citizens, to be free from unreasonable searches and seizures. Investigatory detentions are permissible when justified by an officer's what? Reasonable and articulable suspicion that a person has committed or is about to commit a crime. Okay. Well, didn't you just state up here that he initiated a traffic stop for not having plates on my car? Is that a crime? Or temporary tags? Is that a crime? Is that a crime? They're going to have one hell of a time at this at trial. I mean, I don't know how they're going to get around this. Oh. What? Where's my jury instructions? Oh. Okay. How are they going to get around this one? Crimes or public offenses are divided into two categories: felonies and misdemeanors. Every public offense is a misdemeanor. An infraction is a civil public offense not constituting a crime. That's the Criminal Practice Act, and it's also Idaho Code 18-110, grades of crime. Crimes are divided into felonies and misdemeanors. Idaho Code 18-111, felony, misdemeanor, infraction defined. A felony is a crime which is punishable with death or by imprisonment in the state prison. An infraction is a civil public offense not constituting a crime. So, yeah, based on his own statement, citing this case, investigatory detentions are permissible when justified by an officer's reasonable and articulable suspicion that the person has committed or is about to commit a crime. But see, the State versus Clark case, see, they're citing from 2013. Why don't they already know that State versus Clark in 2019? That you can only make an arrest. Well, because that had to do with the domestic violence stuff. But see, this is that RAS, reasonable and articulable suspicion. And what's that? Is it Texas v. Smith, right? What is it? Texas versus... drawing a blank on that one. I think it is Texas versus Smith. But I could be wrong. Investigative stuff. They have to articulate the crime. What crime do you suspect me of committing? Right now, you have to inform me of the crime. Well, I'm just detaining you. No, you've placed me under arrest. what's the crime? You're depriving me of my personal liberty. Like I asked, well, am I free to go? No, you're not free to go. Okay, then what's the crime you're placing me under arrest for? Well, I'm asking you for your driver's license, registration, and insurance. Why you don't have plates on your car? I'm like, but what's the crime? Right? Reasonable suspicion must be based on specific, articulable facts and the rational inferences that can be drawn from those facts. Reasonable suspicion requires more than a mere hunch or incoherent and unparticularized suspicion. The reasonableness of the suspicion must be evaluated upon the totality of the circumstances at the time of the stop. So the second he turned his lights on to make the stop, that's the totality of the situation right there. What crime did you witness? What crime are you suspecting me of? This standard requires less than probable cause, but more than mere speculation or instinct. This is case, right? Case law. Well, let's go by the common law. And see, they're citing from 1999, 1988, right? 2002. Where's the State versus Clark case of 2019? This has already been cleared up. Every last case that you have cited here is void for any effect except for the State versus Morgan, with the limitations of what kind of crime? Felonies or breaches of the peace. I know, right? They make way too much money being corrupt. Texas v. White. Thank you, Wendy. Texas v. White. JJ, good to see you, brother. 28 USC 1455. That's funny you would mention that. That is so odd. Because wait, where is it? What? Where in the hell is my document? I did one on a federal I tried to do a federal removal. And then the clerk at the federal court told me, "Oh, I don't know, what do you mean? What?" I'm like, I'm doing a removal from a state criminal case, from a state court to a federal court, under 1455, 28 USC 1455. Oh, no, you can't do that. I'm like, 28 USC 1455 says I can. Well, you can't do a criminal case. I'm like, I'm the defendant. Read 28 U.S.C. 1455. No, I've never heard of that. And I'm like, well, just because you haven't heard of it doesn't mean that it doesn't exist. I'm like, and then she went back in the back, and next thing I know, she got U.S. Marshals coming up there trying to harass me. And then she prints this thing off and gives it to me, and that I hands it to the U.S. Marshal, and the U.S. Marshal hands it to me. Say, here you go. And I'm like, okay. You could see where she printed from the screen. She was under 1443 for civil, but there's a tab right there under federal removals from a state court to federal court. She did not want to click on that tab for a criminal case under 1455 and print that out, because that's what I told him. I said, right there, look, see that tab right there where it says criminal? I'm like, this is a criminal case. This is pursuant to 1455, not 1443, which is what she's trying to cite here. I said, pull it back up. Click on the tab that's right here in this, what you printed out. It's right there, criminal. Give the procedure for that. Oh, no, I'm not doing that. Yeah, because she didn't want to be proven wrong. All she would have had to have done was click on that tab, print that sucker out, and bring it out. We had all looked at it and went, yep, you're going to accept his petition for removal pursuant to 28 U.S.C. 1455 to remove a criminal case from a state court to the federal court. Now, one of the other things here real quick is a determination that reasonable suspicion exists, however, need not rule out the possibility of innocent conduct. Uh-oh. Uh-oh. Like not having plates on my car? But, I mean, based on their own thing, investigatory detentions are permissible when justified by an officer's reasonable and articulable suspicion the person has committed or is about to commit a crime. What do you mean, about to commit a crime? What do you mean? No. Making an arrest is depriving me of my personal liberty. That's an arrest. If I'm not free to go, then I'm under arrest. And at the time of the stop, you have to articulate what the crime was. What crime are you suspecting me of? Well, I pulled you over because you didn't have plates on your car. Well, that's a civil traffic infraction. That's not a crime. So, anywho, folks, that'll be it for tonight. And I've got the next 2 days, I've got to get all of my jury instructions done and get them submitted to the court. I have court on Monday, the 23rd, and trial on the 26th. But I'm wondering after I file all of these, and then, of course, then I'm going to file my motion to dismiss challenging jurisdiction again. And we'll see what happens. All right. Thank you all for being here. And if you'd like to help support, get on KIRKSLawCorner.com. I put out all of the donation links there, Patreon. Join Patreon if you want to do it that way. There's the Buy Me Coffee. That one's working now. Although I'm waiting to see if it gets finalized and transferred. I made a request. I got it approved. So we're waiting to finalize that. But yeah. Otherwise, over to the office. 6477 West Fairview Avenue, Suite G as in golf. 83704, Boise, Idaho. For any of that cash wrapped in aluminum foil, any gold, silver coinage, anything like that. All right. Don't forget the tollandroll.com website, and for any donations over there for what we're working on through there. That's also in the, should be plastered on that. All right. God bless. Have a wonderful night, and we'll see you. I don't know. I might actually take Wednesday night off because of trial. So, yeah, I'm probably going to do that. Take Wednesday night off. Because I'll have trial. Oh, wait, no. That's not this Wednesday. Never mind. Next Wednesday. This Wednesday, we'll see you Wednesday night for Wednesday night workshop.